Today we're going to talk about the recent decision of Railpro Services and Flavel. That was a quite sad case in which Mr. Flavel had been a train driver, had 40 years experience. So he had to go through a sort of retraining process. During the course of one of those supervisions, there was an accident which led to $5 million worth of damage. There was the possibility of termination at that stage, but due to his long service, he was in effect given another opportunity, but had to be assessed for competency before being allowed to drive trains, which obviously was an inherent requirement of his job to be able to drive the trains. When he was actually going through about to commence the competency assessment, he started feeling sick and unwell, and informed the person who he was going to assess him that he couldn't continue, and it would be a danger for him to drive the train or to undergo the assessment of competency by driving the train on that day. His employment was terminated on that day. So he commenced proceedings for adverse action, claiming that the dismissal was disability discrimination and also that it was a breach of the general protections because he was being terminated because of the exercise of his workplace right to health and safety at work. At first instance, the judge found in his favour on both grounds, but found that that Rail was aware, or should have been aware in effect, that he had a psychological condition on the day of termination because of the way he reacted in the assessment. The federal court totally dismissed that and said it was glaringly improbable that Rail would be aware of his post-traumatic stress just because of the way he reacted in the assessment. Nevertheless, Mr. Flavel was still successful because they found that it was an exercise of his workplace right to a safe workplace that led to the termination.
I definitely agree with the appeal decision. I think it makes sense that they can't have known that he had a physical or psychological condition. And in terms of adverse action cases of the knowledge of the decision maker, I think it's just makes a lot more sense than the first instance judge. I also think there was a narrowing of the damages for distress, hurt and humiliation down from I think $25,000 to $7,500, and I think that was appropriate and in keeping with past case law.
The reason they ended up in this situation of still losing, even though it went to the federal court, is the rush.
Absolutely.
Why did they have to terminate him that day?
That's right.
Now, if they had gone through the process of, taking some proper time to look at what was happening medically, it's almost certain that they would have found that from all the evidence that it came out that he wasn't in fact able to do the inherent requirements of the job, but they just rushed.
And I think that's
terminated
probably
him immediately, and it got them into trouble in both the general protections or the disability and the workplace right.
That's right, and you can see it's probably informed by the $5 million in damages due to the crash, and then they've just hastily made this decision when they really needed to pause and, arrange a meeting with him, sit down and discuss what was happening, send him off for medical assessment, etc.
And there's probably been some frustration because they've felt like, well, we've done the right thing, give him a chance, then he can't go through the assessment. But it is unusual and disappointing for such a large organisation that they would rush and to do it on that day. Because when somebody, whether it's valid or not valid, when someone plays the health and safety card, as he did turns out legitimately on that day, it's just a sign that you're going to have to take some time, even if it's only a couple of weeks.
And it was ultimately the court sent it back for hearing on the compensation issue because Mr. Flavel was not capable of returning to work immediately. The trial judge had incorrectly found that he could have returned within a month, I think they found, but it was an error and he couldn't have returned for over a year. So chances are Railpro could have been able to terminate him had they followed the correct process.
But I do think it's one of those situations which will happen where an employer is disapproved of because of their conduct in relation to the quick termination. So it's really hard to understand what excuse could be made for it. It's really one of those very unfortunate stuff-ups.
I think it's interesting in terms of what it will open up in adverse action for cases in terms of people exercising their health and safety rights in the workplace, and whether that's going to lead to some other decisions, because a lot of the previous decisions in that area haven't been substantiated.
Yes, and there have been uncertainty about whether that is a right or an
Yes.
obligation. Whereas
Of
this
yourself
case,
and of others.
in the federal court,
That's right.
is very clear that it is a right. And I must say I found it's just an obligation, not a right case is quite difficult to understand myself. I think this decision
This is more in line.
is more in line.
Mm.
But as I say, it's just another reason, along with disability discrimination, work health and safety, etc. You've got to proceed cautiously in situations like this.